Ayubowan, Vanakkam, and welcome. It's July 2020 already. And just like every professional, every business, every strategist who is trying to consolidate their strengths and be attractive in business, it is relevant to a country as to how they should be attractive for investors. This is the 9th webinar of the BASL series, and today's topic is investment laws and policies reaching out to the world. It is my pleasure to introduce today's panel. We have with us Dr. Rohan Pereira, President's Counsel, formerly a member of the United Nations International Law Commission and legal advisor to the Ministry of Foreign Affairs. Uppul Jayasuriya, President's Counsel, who served as chairman in companies in the likes of State Trading Tractor Corporation, Ceylon Oils, Ceylon Chocolates. He is also a past president of the Bar Association of Sri Lanka. Rajaratnam Selvaskandan, attorney at law, senior partner of Warners. He practices in the areas of law including real estate, construction, large-scale development projects. Dr. Asanga Gunawansa, attorney at law, who is an authority on construction and commercial law and serves as the chairman of the Sri Lanka International Arbitration Center. And this evening, we are privileged that our is Surendi Silva, attorney at law, who is a counsel and a consultant of special projects at DL&F Deserums and is a director at the Colombo Stock Exchange. Gentlemen, over to you.
Thank you, Tanya. Good evening, ladies and gentlemen. Welcome to the 9th webinar. The topic that will be under deliberation today is investment laws, policies, reaching out to the world. So the topic by its very title is an extremely broad topic, which covers or encapsulates a number of areas. Given the wide area of the topic, we will focus this discussion today solely in relation to foreign direct investment. We will not be touching on capital markets. That's for a good reason, because the Securities and Exchange Commission at the moment is in the process of formulating a new law, which will bring about comprehensive changes to the capital market structure. So I believe that would be a topic of discussion by itself. When we discuss about foreign direct investments, there are a number of key legislation that as lawyers, sometimes as other investment advisors, that one has to look into. As a moderator, what I will first do is set out the key legislation that we will be looking at this evening, and then identify our experts who would be going into more detail in relation to these areas. One of the key aspects that one would look at when advising in relation to a foreign direct investment is as to whether the national, the foreign investor, is a national of a country that is protected in terms of a bilateral investment treaty. There are, I believe, close to 30 or more bilateral investment treaties that have been signed. Some of them are not in force, but most of them are still in force. Dr. Rohan Pereira, President's Counsel, who is an expert on this area, would share his knowledge and would deal with the nitty-gritty relating to these aspects and would give you a lucid exercise on explanation as to why the governments would be signing these agreements, these investment treaties, and the protection that is generally accorded to nationals of these states. Then another key aspect, a law that will come under consideration, is the Foreign Exchange Act. There was a new Foreign Exchange Act that was brought in the year 2017, which repealed the previous Exchange Control Act. This has made far-reaching changes to the previous regime. It has developed and categorized transactions as current transactions, capital transactions, and streamlined the basis on which investments could be made in Sri Lanka. A foreigner cannot just come and make an investment by opening a current account in a licensed commercial bank. Mr. Rajaratnam Selvaskandan, who is an expert in this area, would be dealing with this aspect. He would be touching on the areas, including certain areas that are restricted, certain industries that are prohibited from protected foreign investment. We would be going into a policy consideration in relation to those. And also, Mr. Mr. Selvaskandan would also be looking at the areas that in relation to foreign investment in the real estate industry, which will be condominiums and leasehold rights. Then we have Mr. Upul Jayasuriya, President's Counsel, who will be looking at the BOI laws and SDPA, the Strategic Development Projects Act, which was brought in the year 2008. As most of you know, Mr. Upul Jayasuriya has literally been on the other side of the fence as well. He served as the chairman of the Board of Investment. So there's no other person who is more experienced in sharing the knowledge from the insights, sharing the insights of within the BOI and its workings, and also the investors and the issues that they faced with the BOI being an investment facilitation vehicle. We have Dr. Asanga Gunawansa, who has a truckload of experience in dealing with investment disputes. So he would be delving into this discussion by looking at what are the measures that would be taken in protecting investments. What are the safeguards that you would advise an investor to include into its contract documents, or what to be wary about when bringing in an investment into this country. So within that broad framework, let me first invite Dr. Rohan Pereira, President's Counsel. Dr. Pereira, you're with us?
Yes.
Yes. Dr. Pereira, could you explain as to what is actually contemplated as an investment under these bilateral investment protection treaties and the key features that seduces or attracts governments to enter into these? We find on numerous occasions when heads of state visit foreign countries, or when they come to Sri Lanka, the leaders are signing these bilateral investment treaties. What is so alluring about this?
Thank you, Suren. I think let's look at the basic objective entering into a bilateral investment treaty. Is to create what is called investor confidence in your country. How do you generate that confidence? Is by conferring a bundle of rights. And among a whole host of these rights, first of all, as you said, there's a broad definition of the term investment. It is a non-exhaustive definition, inclusive definition. But through arbitral jurisprudence, certain qualifiers have come into play over the years, like duration of an investment, of an element of operational risk, and so on. So the precise contours are evolving. The key features, I would say the pillars of the treaty, first is the obligation to grant full protection and security. Sri Lanka's first ever arbitration was the AAPL versus the Government of Sri Lanka and the Sri Lanka-UK Treaty. And that was the first ever investment dispute to go before International Center for Settlement of Investment Disputes, arose out of destruction of a prawn farm due to military operations. There it raised the question of full protection and security. What do you mean by full protection and security? What is the standard? It was argued there the standard was strict liability, but the tribunal held standard is one of due diligence, protect foreign investment in your territory. And also, arbitral jurisprudence shows that security is not limited to physical security, but it also involves legal and administrative security. Similarly, fair and equitable treatment be granted to an investment. There it is really, what we are talking of is due process. Due process, application of law without discrimination, transparency, and so on. So these are the two key pillars: full protection and security, and fair and equitable treatment. And they go hand in hand. at the Sri Lanka-UK treaty, they are all both dealt with in one article. Thirdly, and there are a number of others like expropriation and so on, free transfer of capital and returns. But most importantly, in terms of these treaties, an investor has direct access to international arbitration. He does not have to go before domestic courts. And at the time of concluding the treaty, the two states parties give their consent in advance, refer future disputes involving their nationals or companies, to refer the dispute to the International Center for Settlement of Investment. This is a very innovative provision where a state has, at the time that you conclude the treaty, has already consented in advance in respect of any future dispute that may arise. So all that the investor has to do is trigger the consent requirement by filing an application. And that is precisely what happened in the AAPL, is Asian Agricultural Production case, when the investors' prawn farms suffered loss. Sri Lanka had already consented in terms of the UK treaty, and the moment investor sends an application to the International Center, the consent element is satisfied. So that is seen as a far-reaching innovation, and all this bundle of rights is supposed to generate this element of investor confidence. Very short, that is the essence.
Thank you, Dr. Perera. Dr. Perera, there was a recent ICSID arbitration involving Sri Lanka, which was determined in favor of Sri Lanka, the Montrose ICSID arbitration. In that, there was a very interesting finding or an interpretation that was given as to what is a protected investment. Are you in a position to elaborate a bit further on that, Doctor?
Very briefly, but before that, let me say this issue of what is a protected investment came up in another arbitration involving Sri Lanka, the Mohali Arbitration. Mohali versus Government of Sri Lanka, a power plant, power project. Now, there what the investor or alleged investor tried to do was to claim pre-investment expenditures in terms of the Sri Lanka US treaty. There, Sri Lanka successfully argued that what is protected under the treaty is an admitted investment. So therefore, any pre-investment expenditures, in anticipation of a possible future investment, they are not covered by this so-called broad definition. Now, even here, the recent arbitration Montrose, even there is a contribution of a certain duration to an economic undertaking. And even before that, this element of making a contribution to the economic development of a state has been expressed in different ways. So I think that is the observation I have on that.
Yeah, so far, viewers, the Montrose ICSID arbitration was an arbitration relating to a land near the Yevanna. Some of us may be conversant with that. It was the former electroplastic land. This land was acquired by the government, and then thereafter the company went into ICSID arbitration. And the arbitral tribunal held in favor of the government in March of this year, where it said that a bare investment by itself is not sufficient. There should have been an operational risk that has been undertaken. The project at that time, they were contemplating to develop a hotel, but the tribunal found that it was only at a very aspirational level. There had been no contracts that have been signed, no developments that have taken place, and no operational risks that have been undertaken. Unlike in the AAPL arbitration that Dr. Perera referred to, which is the prawn farm, that was the very first ICSID arbitration, I believe, Dr. Perera, where
yes,
in fact they had come and undertaken and they had carried out 2 shipments to Japan. So there was in fact, a business, there was an operational risk that had been undertaken by the investor in relation to that. Dr. Pera, from you, if I may just move on, Mr. Upul Jayasuriya, President's Counsel. Mr. Jayasuriya, the BOI. Now, when we talk about the BOI, I mean, people talk about Section 16 agreements, Section 17 agreements, and also why would an investor want to invest and get a protection by signing an agreement with the BOI? I mean, is there actually some material benefit, or are they just lulling themselves into some false sense of comfort?
Well, the BOI started its operations and the law was promulgated in 1978. Now we have had at least 40 years since that time. Have I been heard by everyone? Hello?
If you can be heard, I think it's probably the
Okay, right. Now, what has happened in the recent past, there have been a new, under the BOI, there is Schedule B. Schedule B, there are several acts that are referred to in the Schedule B, in which the authority to take decisions under those acts is vested in the Board of Investments. Now, such as, for instance, customs law, immigration law, and more importantly, the Inland Revenue law and the exchange control law. Now, there are many foreign entities that are seeking to bring in money and then take money out. Wherever they had to be taken permission from the exchange controller, it has to be, it can be given by the Board of Investments. So that is the whole idea of creating the one-stop shop. But now with the two new legislation that are coming, the new tax law and the new exchange control law, they are not included in the Schedule B. So this is one shortcoming that I see. What is now left of the BOI in Schedule B are the customs law and the immigration law. That again, whatever the recommendations that the BOI makes, the immigration authorities accept it as it is. That's still good. But what is most important to the investors is to see what benefit they can get. Now, with the new tax IR law that has been brought in, there is a capital allowance that is being given. The entirety of the investment that you make is deductible from your taxable taxes that you have to pay over a period of, depending on the amount of the investment, up to about 8 years. And beyond that, there is also 50% tax holiday that is being given. But the BOI has no relevance there again. So it is not an encouragement at the moment for an investor to come through the Board of Investments. So the investor facilitation to be made under one roof will become either a nightmare or it becomes unrealistic. So I think these are areas that have to be looked into by the authorities. Even previously, when I was there, I was trying to persuade the government at that time, but these laws came in later on after I relinquished office. So these are things that has to be taken into consideration by whichever the government in power, and then make these small changes. Then one of the other issues is that the land law that are in application. Of course, there was another amendment for the public quoted companies. There is no, the land ownership of land is now no more restricted for the public quoted companies because the ownership keeps on changing. So you can't have you can't monitor as to at which point of time the ownership, the shareholding of the foreigners go beyond 50%. So therefore, that exemption has now been given. Now there is this up to fourth floor and above, for condominium properties, there was a possibility for any foreigner to buy properties, but now that has been taken off. So we have to look at it practically at the total picture. Now, it's very important as at the moment that with the COVID situation, there are changes that are taking place in the world scenario with regard to investments, particularly in China. There are many US companies that are supposed to be looking at options of pulling out of China. And also there are issues in India. There are issues between India and Pakistan. So Sri Lanka offers, with our geographical location and also practical solution, if we can offer to these investors to bring in these monies. The new exchange control law that we brought in has a lot of flexibilities as against the previous one. But in answer to your question earlier, whether the BOI law has any relevance to come through the BOI for an investor, then that remains still a question. You also asked me the question at the very beginning, what's the significance of Section 16 and Section 17? For a young lawyer who wouldn't much know about the difference between these two sections, Section 16 is simply a registration where the investment threshold is only $250,000. But you don't get any exemptions. You don't get any exemptions under Section 16. There is no agreement. There's only a approval that is being granted by a letter. It is only under Section 17 that you have the option of being able to import goods other than those that are in the negative list, free of custom duty. Negative list is fairly large. One must also look at the options. We can't make that too large also, for the simple reason, particularly with these construction projects that are coming, we must also look at how the country benefits. Country can benefit in such projects only with the development in the industries, the other supply chain. If we can integrate that supply chain into these constructions, like the furniture, the doors and windows. Now, for instance, the tiles are already there. Cement and steel is not there. Steel can be imported, but there are so many industries that are manufacturing or rather rolling steels in Sri Lanka. We don't have steel in Sri Lanka. We import and roll steel. So overall, when you look at it, I think the most important thing would be the relevance of BOI. Coming back to your original question, the relevance of BOI. If that is to be done after 40 years, we have to have a fresh look at the BOI law and then look at how easy we can make it. Now, for instance, under the BOI law, if you are taking an injunctive relief against the BOI company, you have to give 1 month's notice. It is a mandatory requirement. Now, but issuing summons and serving summons is a nightmare. In the ease of doing business, Sri Lanka is the 165th country out of 189 with regard to enforcement of contract. Now we are overall 99th position in the world internationally, but we have to be able to bring this index from 99th position to about at least 50. If you can do that, then the people will be looking at us. The investors will be looking at us. Then the relevance of the BOI can be made possible. Now, being lawyers, we are all lawyers discussing these issues. In the Doing Business Index, there are about 4 areas, not only enforcement of contracts, paying taxes, protecting minority interests, then registering property. Most of these areas are within the lawyers' armory and the legal spheres. I mean, this is where the judges, the lawyers, the attorney general's department, everyone should get together. We should take it forward. How we can have some practical solutions. As we all know, issuing of summons to a foreign company through the Ministry of Justice takes good 2 to 3 years. So these are nightmares for most of these investors who are seeking to invest in Sri Lanka. Without being able to get out of this situation. Now, India, for instance, is accepting service of summons through WhatsApp. So there are so many modern methodology that we can adopt practical solutions. Even the courts have to give credence to these kind of practical solutions, the same way that we, at some point of time, we have tried to bring in video conferencing and evidence to be led from a foreign country, but that came to a grinding halt again as to how the witness can be sworn in and all that. So these are areas, again, the judges have to come out with some practical solution, maybe in a in a judgment or maybe by our Supreme Court rules. We have to address these issues, or by the change of legislation. I'm not saying this in a negative way. I'm saying it in a positive way, because these are areas where the lawyers can get together and establish better relevance of the legal inputs into the attraction of FDIs into Sri Lanka.
Thank you, Mr. Jayasuriya. I think you raised a very important consideration, I think, which has been troubling a lot of investors, and also that is this question. It's the principal enactment, the 1978 GCEC law, Greater Colombo Economic Commission. It set up the precursor to the BOI, included the External Exchange Control Act, and also the Inland Revenue Act, and under Schedule B, where certain exemptions should be given. But now there is a situation as to whether the Foreign Exchange Act, in fact, it comes under the scope of the purview, which comes under Schedule B. Do you think, is it a legislative oversight, or is that something where the government has taken a policy decision to take this act outside the scope of the BOI?
I don't think that it's intentionally left out of it. I think it's the oversight. It's an oversight. I think we have to bring it to the notice of the government in power, maybe the minister in charge of it, and then draw their attention to it. But of course, the IR law has now no relevance, because it doesn't recognize any BOI entities, because they brought in these capital elements. But there again, the payment of taxes, as I can see, the payment of taxes, we are fairly low down in the ease of doing business criteria. So there again, we have to increase, we have to do better on the doing business indicators, without which we will not be a country of relevance for the investors to look at.
Thank you, Mr. Jayasuriya. Mr. Selvaskandan, if I may weigh in on you now, I mean, given your versatile personality, I'm going to throw two aspects to you. I think one aspect was already covered to some extent by Mr. Jayasuriya as well. The Foreign Exchange Act, the 2017 amendment, brought about a complete new transformation to the foreign exchange, the transactions that could take place and the manner in which it could take place. Could you give us an overview of some of these changes that have been, the material changes that have been brought out? And also, we still find that certain industries and sectors are restricted to foreign shareholding. Some are actually prohibited. So if we can just draw on your experience to share your thoughts on that. And also, the other aspect I would like you to help our viewers with is as to the restriction that has been imposed on foreigners in relation to ownership of land. If you could touch on those restrictions and also explain, in your view, what is the policy considerations, I think we would be much obliged. Yes, Mr. Selvaskandan, over to you.
Yeah. Ron, the new Foreign Exchange Act brought a complete transformation, as you said, and it liberalized the entire inflow and outflow of funds into Sri Lanka. Now, if you go back earlier, we had this SIA account, and also we call it ECBA, which is an external commercial borrowing account. These are the two accounts you have to maintain. One is to come into purchase of stocks, and another one is to lend money to the commercial entities. But these two separate accounts had caused a lot of problems for those who want to come in to fund certain projects, or to invest in the companies, or to lend money to the companies, because there were a lot of restrictions. And also, you had to go through the central bank to get the approval. If you can recall earlier, the SI account was restricted in the sense you can come and invest in certain companies only. But now, if you see this Foreign Exchange Act has categorically given certain categories where, except there are limitations and exclusions, you can invest in all permitted companies, what they call the permitted investments. So now when you go into the exclusions or limitations, you will see excluded sectors are pawnbroking, retail trade, with capital of less than $5 million US or coastal fishing. These are excluded sectors, what they call it under the FEA. And then there are limitations into certain sectors where you want to come in. You can hold only up to 40%. Or if you want to have a higher percentage of shares, you have to go with the BOI approval. The BOI can grant approval if you want to have more than 40% shares in those companies. And those companies are production of goods where Sri Lanka exports are subject to internationally determined by the quota restrictions, and also growing and primary processing of tea, rubber, coconut, sugar, and spices, mining and primary processing of non-renewable natural resources, timber-based industries using local timber, deep sea fishing, mass communications, education, freight forwarding, travel agencies, and shipping agencies were restricted. There are 10 companies where they have these 40% limitations. And then you have a limitation completely where you can do it with the approval only. Those are air transportation, coastal shipping, and also large-scale mechanized gems, lotteries, industrial enterprises, the second schedule to the Industrial Promotion Act. So here you have to get the permission. These are the three areas. One is excluded sectors, other is the limitation with 40%. You can come in with the BOI approval. Other one is the limitation where you have complete limitation. And all others come under permitted category. Now, when it comes to the lending to the companies, those days you have earlier act had the provisions where you have to give 3 years. First, we had $10 million, a cumulative of $30 million over 3 years. Then they come and remove those limitations, and they said you can lend money provided certain conditions are met with. For an example, you have to make provisions against the foreign exchange risk, and your balance sheet should be good enough to deal with the debt repayment, like few conditions were brought in. But now, under the current act, there is no such restrictions imposed if you want to bring money and lend to the companies. Now only they say is the minimum requirement is you have to have 3 years term in those loan what they provide to these companies. So in that sense, now bringing in money has become much more easier. But however, I must say, most of the companies in Sri Lanka, they require these funds for restructuring purposes. But when you do restructuring, you quite often find these companies are having landed properties as well. So on one hand, you are permitted to bring money to invest in these companies or lend to these companies. On the other hand, we have a restriction how to deal with, because the foreigners cannot, if anything goes wrong, for them to take the pledge of the shares and become owners of the company as a security, they won't be able to do so because they cannot become 100% owners when there are landed properties involved. So what I am suggesting is we may have to have some sort of flexibility here in order to permit certain restructuring where landed properties are involved in the company in these sort of funding arrangement. That is one of the issues that we are quite often faced in restructuring these companies and also bringing funds under the FEA, the relevant companies. Then if you go into the, there are one issue I have to highlight is if you see the FEA, you have a resident, non-resident. That's how it has been defined. But when we come into Land Alienation Act, it is a foreigner. So now you have a resident who can invest in the company, then a non-resident has to comply with the matters I mentioned earlier. But when we come to the landed property, you have to have an issue because they cannot have more than 49.9% there, right? So the foreigner is defined differently in the Land Alienation Act, and whereas a non-resident and the FEA is defined differently. Now, another point you can see, when it comes to the resident, you see the order under which the FEA, we got the order 31, section 31, it clearly says who is a resident. A company incorporated in Sri Lanka, irrespective of the shareholding, whether it is a foreign shareholder or who has a majority shareholder is immaterial. It is considered as a resident of Sri Lanka. Now, when you come into these limitations, where mining and all other activities, the 10 activities I mentioned earlier, how do you define? If a Sri Lankan company, if they have foreign shareholders, can they be considered, those companies, can you consider them as of Sri Lanka? So these are the issues that we have created, issues under the FTA and the Land Alienation Act. Coming back to the ownership of property and the foreigners coming into Sri Lanka is, now as Mr. Upul Jayasuri has said, the fourth floor and above has been removed. There is no issue there. So now the foreigners can come and buy at any level of the high-rise buildings. There is no restriction over there, provided entire money is brought in and paid prior to the deed of transfer is executed. So those are the areas that have been dealt with under these two acts. And I must say, under this current act of FTA, it is much more flexible, and the entire process has been utilized in order to do business in Sri Lanka by the non-resident Sri Lanka.
Thank you, Mr. Vaskandan. I mean, you were touching on the aspect about the foreign ownership of land. Still, foreigners cannot own freehold property. Do you think that is still relevant, or is it something that should be looked at?
If you look at the rest of the countries, also have similar restrictions. Because whether you have a freehold or 99-year lease, it doesn't matter, as long as the conducive environment is created for them to do business in Sri Lanka and to own land and do business. Now, I always say, when we talk about the development particularly, we have to look into different aspects of the development. The reason is, the investors who are coming, are they capable? It doesn't matter whether it's a freehold or 99-year lease that we give to them. But the most important aspect is whether these developers are really capable of completing the project. Do they have the relevant funds to do so? You can see in Sri Lanka at the moment, there are projects just idling. The reason is the developers who have come and take these lands, they are unable to complete those projects. So in order to achieve a good development potential for these countries, we have to have certain regulations in place for that. We have to vet those investors properly before we give any this kind of landed property. For me, whether it is a freehold or a leasehold is not a major issue.
Can I chip in at this moment? Now you said about the ability of the investors to be able to bring in the money when they are capable of making the investment. In that kind of a situation, I think I can remember when I was at the BOI, I had come out with certain out-of-the-box kind of safeguards where I said that, look, okay, you said that you are going to bring 1,000 million into the country. So, we can't, we are also beggars, but we can't be choosers. So I have given them, say, for instance, 6 months time. 6 months time, you bring in your first 200 million. If you don't bring the 200 million within the 6 months period, the project stands terminated ipso facto. So we have to come out with out-of-the-box solutions, but also keep a tab on it and discourage if they are not going to bring the money within the stipulated period of time. If we strictly say, no, we want to look at the money, $1,000 million, nobody has money in the pocket when they come to for investment into any country. They don't have that amount of money in their pocket. Either they'll be borrowing or maybe they'll be looking for the investors and so on. So we have to be a little open-minded and have some checks and balances so that we can have it regulated, but still encourage the people to come in.
Thank you, gentlemen. We'll come to some of these issues that are faced by investors and also what we have encountered as practitioners in advising clients. Let me now call upon Dr. Asanga Gunawan sir. Dr. Gunawan sir, you have had a tremendous amount of experience in dealing with investment disputes, not only in Sri Lanka, but also across the seas. Dr. Gunawanta, what are the measures that an investor should look at in order to protect his investment, and are these actually adequate at the moment?
Thank you, Suren. Yeah, so from an investor's perspective, one of the key things that they have to do when they come into a country, especially a country like Sri Lanka, where there are major investment related risks, is to do a proper due diligence to see the legal environment, the regulatory environment, and also to see whether the investment is to be made in a sector that is approved by the government. So for example, from that perspective, one of the first things to do is to identify the investment area in which the investment is to be made. And then like Mr. Selvaskandan and Mr. Jayasuriya said, to check with the existing legal and regulatory framework to see whether those are approved investment areas. Then the other thing that you need to check is whether the investment is being made as a response to a government tender invitation, or whether you are going to do it, in the form of unsolicited bid. Because based on whether it's an investment in response to an invitation to bid or unsolicited bid, the applicable regulatory measures are different in terms of our public procurement guidelines. Now, there I have to also highlight the issue. We have public procurement guidelines which have gone through amendments twice, I think. The latest version is the 2006 version, if I'm not mistaken. But then a few years ago, the government suddenly introduced what is called the Swiss challenge mechanism. And some of the investors were not even aware of, why the Swiss challenge mechanism was in place and what was to be achieved by doing that. So that kind of situation sends the wrong signal, to the investors. So the public procurement process needs to be very carefully considered. And then also another key consideration is to see whether the project is to be done with 100% foreign direct investment, or whether it's to be developed in the form of a public-private partnership. If you look at the government procurement guidelines, as well as various policy statements that the government is coming up at different times, the term public-private partnership is very widely used, and says that, and these policy statements say the intention of the government is to develop all the infrastructure going forward in the form of public-private partnerships. So the investors are very keen to see whether when they walk into these public-private partnerships, is it actually meant to be a true legal partnership where the government doesn't wear the hat of a regulator after awarding a contract and just regulate the contract, but do they actively participate in the project? So if I may give an example, the Colombo Port City project is a good example, where it was meant to be a public-private partnership, but then suddenly there was a government change and a regulatory cap was put on and the project was suspended for almost 18 months. And those type of situations also send the wrong signals as far as investors are concerned. Then the other thing to check is who are the lenders to this project, because most of the foreign direct investment projects that we are looking at now, which runs into millions and millions of dollars, no investor will come forward and put 100% equity in a project like that in a country like Sri Lanka. So therefore, if at all, they will put 20 to 30% of the investment cost as equity, and they will raise the balance money by way of project financing going to institutional lenders. So most of these institutional lenders would want government guarantees, sovereign guarantees, in other words. Then the question is Sri Lanka providing sovereign guarantees? Now, in the past, the government has, but the current policy is not to issue any sovereign guarantees. In those situations, the lenders would insist in walk-in rights, for the project in the case, in situations where the investor is not able to carry forward the project, and they might also want to enter into direct agreements with the government. So the investor will have to discuss with the government and see whether the government is open to the idea of entering into a direct agreement with the lender. I have also seen investors coming in and then falling into trouble, as Mr. Jayasuriya mentioned earlier, as a result of not having done proper feasibility studies. Sometimes there are feasibility studies that are done locally, and on the basis of that, tenders are invited. But if you really look at it very closely, there has been no environmental impact evaluation done at the time the investors are called upon. And then once the investor comes in, the government gives an undertaking saying that we will do the EIAs and issue the licenses, and you have to do the project. That leads to a situation where, for example, if public interest litigants, come forward and challenge the project on the basis that no proper EIAs have been done, the investors will try to wash their hands off, saying that this is not our obligation. Look at the concession agreement. Government has undertaken that obligation to do the EIAs on their own. And I don't think that's a very conducive environment, to do investments. The investors are also very keen on the expropriation regime. Now, if you look at the BOI website, the BOI website clearly says that Sri Lanka doesn't have a history of, nationalization or expropriation, which may correct partially, because since the 1970s, we may not have done that. But then, as you know, the revival of Underperforming Enterprises Act gives the wrong signal. Although it in a schedule lists certain companies as underperforming, there is no restriction on adding further companies to that, which can be done. The other area that the investors are interested in is to see whether the government of Sri Lanka has signed any investment-related treaties, either at the multilateral level like the Exit Convention, or bilateral treaties, under which they might get some investment protection. And also whether they will get most favored nation, status treatment, when they do their investments, in a country like Sri Lanka. Also, they are very, very keen to look at the aspect of enforcement of contracts. Now, when we speak about enforcement of contracts, according to a recent report done by the World Bank in 2019 or early part of 2020, Sri Lanka is ranked 99th in the Ease of Doing Business Index. And according to the World Bank, the time taken to enforce a contract in Sri Lanka is approximately 1,300 days. And as far as enforcement of contracts are concerned, our ranking is way down. It's 164th out of 197 countries that they have looked at. So that really doesn't give a very good signal to the investor. And I think as far as the timing is concerned, World Bank has got it wrong. You and I both as practitioners know that, most of the time it takes much longer than 3.5 years to get a contract enforced in Sri Lanka. And then, I'm familiar with situations. I'm involved in some, litigation at the moment where there have been international arbitration awards made in favor of investors about 5 years ago. And then state has appealed, and then there were parallel applications made. And now they are before the Supreme Court, then the matters are yet to be listed. Almost 5 years have gone by and the investors have not seen the color of their money. So those are the key considerations. And if I may just touch upon taking a few minutes on the enforcement aspect, which I think is very, very important. In a country like Sri Lanka, especially if an investor is dealing with a Sri Lankan entity, to some extent, the government entities are flexible in adopting a third country neutral law as the governing law of the contract. So there may be a Swedish or a Norwegian investor coming into Sri Lanka, and they might not want the contract to be governed by Sri Lankan law, and they might propose English law. So there have been situations where the government has agreed, and also there have been situations where government have resisted and insisted that governing law has to be the Sri Lankan law. So there is no consistency there. And then also, when it comes to the dispute resolution mechanism, more often than not, the government would also agree to neutral third country international arbitration, for the dispute. But when it comes to enforcement of arbitration awards, that's where the situation is. Now, if you look at our Arbitration Act, there's a popular belief in Sri Lanka that we follow the Swedish law, but that is not correct. If you look at our Arbitration Act, there is some Swedish influence, but 95% of it are word-to-word match to the Untittled model law. But as you know, Untittled model law was amended in 2006. And just like the Untittled model law was amended, the English Arbitration Act, the Singapore Arbitration Act, Hong Kong Arbitration Act, all these statutes have been amended because they all recognized there was a small problem with regard to the principle of competence. Whereas in Sri Lanka, we have not amended. Now, if you very closely look at Section 11 of the Sri Lankan Arbitration Act, it creates a parallel jurisdiction where one is able to go and raise a jurisdictional objection before the arbitration tribunal, but you can make a parallel application also before the competent court, which is the commercial high court. So there might be a situation where the arbitration tribunal says we don't have jurisdiction, court says no, you have, or the other way around, which would lead to an absurd situation. Now, how the ancestral model law was fixed, what they gave they made it an appeal. They said, okay, you have to first raise your jurisdictional objection before the arbitration tribunal, and if you are not satisfied with it, then within 90 days you can appeal to the competent court, or whatever number of days. Now, in the Sri Lankan Act very clearly says that only the appeal provisions are only applicable from Part 7 and beyond, whereas Section 11 is found in Part 3. So the application that you can make to the competent court and Section 11 is definitely not an appeal. So it is a parallel application. And there was an instance where the state appeared, on 2 consecutive days, and one day it appeared and objected to a Section 11 application before the Commercial High Court, saying that you can't maintain this application because this has to be considered as an appeal, and in any event, the section should be interpreted not to give parallel jurisdiction because that would lead to absurd situation. The very next day, state came and used Section 11 as an appeal and said that, no, we have the right to make a parallel jurisdiction. So investors are watching this, and they are very worried about the enforcement scenario in Sri Lanka. So those are my preliminary comments. If you have any questions, I'm happy to respond.
Thank you, Dr. Gunawan sir. I think you touched on some very important aspects, which is of matter of grave concern to most investors. That is this dispute resolution, the mechanism that is available. Is it time? I mean, as practitioners, I think we are all familiar that these arbitrations have become, importation. We have imported the civil procedure, court procedures. They are more or less trials, long drawn-out inquiries, lengthy cross-examinations and evidence, and so on and so forth. But when we look at the exit type of arbitration, these are not the procedures that are followed. It is far more restricted. Evidence cross-examination is limited to very, very specific areas. Should we look at setting up investment-specific arbitrations in Sri Lanka, Dr. Gunawan?
I think we can do that. And in fact, there was an attempt to do it. I mean, as you know, we have a state-of-the-art international arbitration center sitting in the World Trade Center for the last 5 years, which is not functioning because the government had not allocated money. Apart from the very first thing they did was to set up the building and do the infrastructure, but no money has been given, to run the secretariat. I think you were also in one of the committees along with me. We drafted a set of rules to use the place as the investment arbitration center, but then no initiative has been taken. So now, I mean, what invariably happens, Suren, is that in most of the investment agreements, you will find an international arbitration clause which provides for institutional arbitration under the ICC rules or under Singapore International Arbitration, rules, or LCIA rules, and so on. Or if not, at least ancestral rules and ad hoc arbitration with ancestral rules. So these are good because once even if it is ad hoc, the ancestral rules provides a certain mechanism to be followed, and the international arbitrators are appointed, and most of these arbitrations will be completed within a very reasonable period of time. But the issue in Sri Lanka is not that, because once the arbitration award is made, right, whether those awards are being honored. Now, as you know, public policy is something very difficult to define. As Justice Masood said, one of his judgments, I think quoting Lord Diplock, if I'm not mistaken, that public policy is like an unruly horse, and it depends on the person who rides the horse. So just like that. And if you look at countries like India and countries like Singapore and even India more recently, have interpreted public policy in connection with arbitration when it comes to enforcement and arbitration appeals, giving it a very limited scope. But in Sri Lanka, that has not happened as yet. And most of the time, these awards are challenged on the basis of public policy. So I think our apex courts also, one of these days, should perhaps go into this and give a clear interpretation to ensure that the public policy provision that is available in the Arbitration Act is not misused when challenging arbitration awards.
Thank you, Dr. Gunawansa. There are a few more minutes on the general session, and while, if I may just take that few minutes just to touch on another aspect, which is also of importance in view of the recent developments that have taken place in advising on a foreign investment, would be the duty that has been cast on professionals, including lawyers, accountants, and other investment advisors in terms of the Money Laundering, Prevention of Money Laundering Act, and also the Financial Transaction Reporting Act, in order to carry out certain due diligences. And if there is anything of a suspicious transaction in nature, there's a duty that is cast on a professional to report that to the Financial Intelligence Unit. However, this excludes an obligation on like a lawyer to disclose any information that is received in a professional capacity where you're advising them in relation to that, or where they have come to you in a privileged communication seeking advice, where they are as to how they could defend themselves in a situation in relation to a charge or a purported offense under this section. So this also is very important, because there is a regulation that has been published in terms of the Financial Transactions Reporting Act as to the types of customer due diligence that should be carried out. There are detailed regulations that have been set out. So I think this is also a very important aspect that as lawyers we should be mindful of in advising on foreign direct investment. So gentlemen, now that we have kind of set out in broad outline the general areas and the matters that kind of arise in relation to investment laws, let me now move to the Q&A. We have received some questions. If I can just first draw on Dr. Ruhan Pereira. Dr. Pereira, are you with us?
Yes.
Dr. Pereira, successive governments over the years have signed various international bilateral investment treaties. Are these actually merely confined to ink and paper, or do they actually provide a meaningful purpose in the context of protecting investments?
Yes, Suren, as I said at the very beginning, basic objective is to create that element of investor confidence on the legal system that is prevailing in your country. Another aspect we have to bear in mind when we talk of the bilateral treaty, it is not just another treaty. It is a treaty which has the protection of Article 157 of the Constitution. It gives a special constitutional protection. In other words, once Parliament approves bilateral investment treaty as being essential for the development of the national economy, then a future Parliament is precluded from enacting any law inconsistent with the provisions of the treaty, except on the limited grounds of national security. I think that's a very special provision. I can't think of a parallel anywhere else, where the Constitution protects this type of treaty. And what are the treaties dealing with? They're dealing with live issues. The first case which involves Sri Lanka in the context of an ongoing conflict was the protection given for the protection given to the investor with respect to full protection and security. It was a live issue because that was a situation of an ongoing conflict. It is in those situations that this type of guarantee becomes something live. Full protection and security, fair and equitable treatment in the system. And thirdly, as I said previously, of course, the recourse to international dispute settlement directly by an investor. Normally, as we know in international law, individual has no status. It's a state, his home state, which must take up the cause of the agreed individual. Here, the individual in his own right, in terms of these treaties, can pursue his claim for international arbitration trial. I think these are the important elements which give it a certain critical relevance. Yeah.
Sorry, proceed, Dr. Pereira. We are listening.
Sorry?
Yeah, please proceed, Dr. Pereira. We are listening.
Yeah. So that is one aspect. Now, one other aspect. Now, we are just talking of expropriation. To look at the articles in the bilateral treaties, It deals with two types of expropriation: direct expropriation or what is called indirect expropriation. Measures, it says, or measures having effect equivalent to an expropriation. That is, without divesting, formal divesting of title, you can take various other measures, which makes the operation of the investment non-viable. In those situations, the investor has recourse, and there have been a number of cases on the basis of indirect expropriation, although there has been no formal act of nationalization or expropriation. So these are real issues which affect investors, and all this goes to show the need to generate investor confidence.
But Dr.
Yes.
Perra, I'm sorry, did I stop you midstream? Or?
No.
Dr. Perra, just for viewers, just so that they are also kind of up to date with these concepts and what they mean. Now, one finds in these investment protection treaties the most favored nation treatment. Could you just elaborate on that?
In very simple terms, most favored nation treatment grant the nationals or companies of other states treatment no less favorable than that you would accord to investors or companies of any third state. So if you give a certain standard of treatment, investors or companies of state, you've already given a certain standard, then in terms of the MFN clause, you are bound to give the same treatment to nationals or companies of the other contracting party. It is not so simple. The biggest debate we now have on the MFN clause is that, is the MFN clause limited only to grant treatment none less favorable than given to a third state in respect of the substantive provisions of a treaty, like fair and equitable treatment, good protection and security, and so on? Or does it also extend to dispute settlement? Well-known case of Nafzeen, on which much has been written, for the first time invoked the MFN clause to insist on a better standard of dispute settlement from a third-party treaty. So incorporate, it's known as a Trojan horse, which attracts various other provisions from other treaties, which the two parties to the treaty had never envisaged at the time they concluded the treaty. So this is, again, the MFN clause has been referred to as an unruly horse or a Trojan horse, because you don't know what you are in for. So now states have taken the precaution when they stipulate the MFN clause to explain in the treaty itself that the MFN clause will only apply to substantive standards of treatment, articles A, B, C, D, E. It does not extend to dispute settlement provision. Because what happened in that Nafzeen case was that in the Argentina-Spanish treaty, it required an investor to go before the domestic courts. And if he cannot get his case settled in a period of 18 months, then only can he go to international arbitration. But in the Spain-Chile MFN clause will apply. You are given better treatment to Chilean investors. So now, very clearly, states are taking the precaution to say that grant of MFN treatment only involves grant of treatment in respect of the substantive aspects of investor treatment, not the procedural provision. Yes.
Thank you, Dr. Perra. Sri Lanka has been before exceed on 4 occasions. One was, as you said, the AAPL, the prawn farm case. The second one was the Mohali arbitration, where I believe you were actively also involved in that. And then the third one was the Deutsche Bank, the hedging fund dispute. And then fourth is the Montrose. So out of the 4 visits to the ICSID, Sri Lanka has won 2 arbitrations, that is the Mohali arbitration and the Montrose arbitration. And then the prawn farm and the Deutsche Bank went against the government. Is that a decent score? Is that of something of significance as far as the investment record of Sri Lanka is concerned, Dr. Perra?
I was only in the first 2, the EPL and the Mohali, and I must say they are balanced awards, because in the first one, the claimant insisting on full protection and security relied on a high standard of strict liability, and the tribunal ruled that all that is required is the international minimum standard of due diligence. Of course, the claimant was awarded actual costs of the damage suffered during the conflict on the farm and loss of lives, but threshold was fairly balanced. Mohali very clearly upheld the preliminary objection of the state, namely that what is protected under the treaty is an admitted investment. So that pre-investment expenditure does not tantamount to a recognized investment, is only some expenditure in expectation of a future investment. And the government managed to get that plea upheld by the tribunal. Those 2, I'm personally aware. The ICSID tribunals have been fairly balanced in there.
So in fact, if you really look at, sorry, Dr. Perra, please continue.
No, I'm responded.
So out of the 2 arbitrations that Sri Lanka has won, that is the Mohali arbitration and also the Montrose, it actually won on a preliminary or procedural objection of jurisdiction that in fact it had not crystallized into an investment. And if I'm not mistaken, even in the Mohali, one of the findings was that it was premature. It was premature, it was at an aspirational level, similar to Montrose. So in fact, from that point of view, I would say that these are very important determinations. And also as lawyers, when we are advising clients, so there is some clarity that the mere fact that there has been an investment, such as purchasing land or you've just brought in some money itself, does not constitute an investment. There should be some kind of an operational risk that has been undertaken by the contracting party or the national or the company. Is that correct?
Yes, I agree. Despite the very sort of open definition of the term investment, they have been interpreted in a particular context.
If I may now move on to Mr. Upul Jayasuriya, if I may just draw on you. You're talking about the BOI and also some of the problems that are faced by investors with the BOI. How do you repackage the BOI? How do you make this a one-stop shop? How do you bring about or make BOI relevant and in order to protect and promote investment and to be the primary investment driving organ of the state?
To begin with, we have to look at it practically. What are the instances where the people have to go from pillar to post? Not only the laws that are there in the Schedule B, they have to be brought back on the Schedule B that have now been left out. But beyond that, not only environmental issues, the land issues, the forest department, the electricity issues, these are the local governments are a huge problem for the investors. Getting the approval from the local authorities, and then there is so much of requests, as you know, made by the politicians, and then they are amazed, appalled by the kind of conduct of some people in those institutions. So we have to look at all that. I think this is an area where even the Bar Association, the lawyers can get together, since we are also dealing with so many other issues with regard to the ease of doing business, as I referred to earlier. Where we can make some recommendations how practically we can look at these things so that the investor will not be pushed from pillar to post. I have been always saying, even in within the BOI, I've been talking with our own people, that the one-stop shop has now become a non-stop shop. We keep going and going in circles. Now, I think there was also some comments made about the arbitral awards. Now, we are talking about, okay, even if there's an arbitral award, they come and challenge it by way of public policy and all that can be challenged at the High Court when they are seeking the enforcement of the arbitral award. But apart from that, there are instances where the Commercial High Court itself has given judgments. I can think of one case where the Commercial High Court gave judgment in 2002. And it went up to the Supreme Court in 2008. The Commercial High Court judgment was to pay 170 million until the transfer of 2 properties. And the Attorney General appealed on that. So they said pay 170 million damages and 1.8 million rupee damages per month, plus legal interest. Matter was appealed upon by the Attorney General, and the Supreme Court affirmed the order of the Commercial High Court. And that was in 2008. By that time, the total damages have come to about maybe about 800 million rupees. Then from that time, the sing-song and the dance begins from there. After the apex court of the country has affirmed the judgment of the original court, then it has taken 12 years. They are still not acted on the judgment of the Commercial High Court. Now the total award is 1.8 billion rupees. Now the 2 lands had to be transferred. Finally, the court intervened and then did a fiscal conveyance in 2018. Having done that, the Attorney General filed another motion in just 3 weeks ago, saying that no, that order made in 2018 is wrong. So this kind of thing, we are talking about the arbitral. Arbitration is something that has been brought in to cut short the long-drawn legal battles. Even the long-drawn legal battles and the awards that are made by the courts of this country if they are to be ignored and not to be acted upon, I think we are just wasting our time. So we have to take some concerted decisions on these matters. Now, Mr. Rohan Perra also mentioned about Article 157. This is an article with which I've been talking very proudly to the international community. But I have not been talking when I spoke of the Article 57, that's a feather on our cap. But still, the Act number 43 of 2011 is a total deviation from the Article 157. Now, some of the enterprises that are listed in the schedule in the 2011 Underperforming Act, the assets have not even been transferred to the properties. So if they are not transferred, then you can't, it is not coming under the underutilized asset. The underutilized asset, the interpretation in the Underperforming Act is that there should have been an asset that has been transferred to an enterprise within the last 20 years, 2 qualifications. So even in such cases where it is not coming under that, the Attorney General also has to look at it, because he too has a huge role to play in this. So it's not a question of just appealing and then delaying the process. Finally, the whole thing is snowballing and it's going to come on our face, and we are going to lose as a country in the long run.
Probably that we have discussed also with the Attorney General's Department when they are also present. Mr. Selvaskandan, yes, please.
I just want to add to what Mr. Upajayasuri has said. There's another case where one of the first investors to this country in 1977, when we opened up the economy, and he went for an arbitration, that company went for an arbitration in 2006. They got the award in 2009, and the Attorney General Department still fighting, and that award has not been fulfilled yet. And this client is so disappointed. And they are making adverse comments about investment in Sri Lanka. They stayed in this country during the most difficult times. So these are the things that we have to look into if we want to bring good investors to this country and to keep it going. The more and more we delay these awards, we are going to have problems.
So probably the Bar Association can create another webinar on that topic with the participation of the Attorney General's Department representatives as well, so that there is a balanced discussion on that topic. Mr. Jayasur, if I may just revert back to you once again, with regard to, there is a school of thought that that it is time in relation to the BOI took a more proactive role. They set up special purpose companies. As you correctly said, one of the biggest issues faced by most of the investors is obtaining these licenses and approvals, so on and so forth. So where they get all these license approvals, everything, and they package these companies, and then thereafter, they either list these companies and sell the shareholding to foreigners or have retain a strategic investment in that. Is this something that the BOI should be looking at, Mr. Jayasuriya?
Yes, definitely so. BOI should be playing a very proactive role, a very practical approach to the problems. Sometimes they would have to even think out of the box and then find their own solutions, of course, within the framework of the law, and proceed with it. But the biggest problem that I can say that the BOI has been faced with during my tenure for the 2.5 years since 2015, and thereafter what has been happening is mostly the liner agencies. The liner agencies that have to play according to the investment facilitation that is being undertaken by the BOI. We have not been getting that support. We are not being getting that support. Now, I'll give you one example. Is a project that was to do plantation of we call this. They were extracting the thing and then they are making powder. This is for the diabetic patients. They are planting it, and in the meantime, what they were doing was they were there were so many deforestation situations, maybe Mohali expansion of the cutting of forests and all that. The Kotalahimbudu trees were cut and fell, and then they were stacked in the magistrate's court. Now, this particular company, having invested nearly ₹1 billion with regard to the laboratory facilities and the extraction facility, they were buying these logs from the courts at auctions, public auctions. Now they brought it to their the manufacturing plant and then extracted the powder, and they were trying to export it. So this was stopped by the customs. I can't believe it. I can't believe it. This was stopped by the customs. Now similarly, the another issue would be another company that signed an agreement with the BOI again for the plantation of 5,000 acres of teak. It's a local company. And they have invested so much of money, a local investor. And after about 15 years, now the teak trees are now come of age. Now they are ready to be harvested and then exported or to be used even locally. Now they were stopped by the forest department, but there is a BOI agreement. So where is the BOI to look at? Can the BOI has no power to facilitate that? So that is why I say, now that we have gone through this practical experience, we have to look at these various options and then include some of these laws. Wherever there has been a BOI agreement that has been entered into, this is not an illegal provision. We are not trying to print money and then distribute in the country or something like that, or even whatever the industries that are prohibited, as Mr. Selvaskandhan rightly referred to. Within the framework of the law, whatever the BOI has entered into these agreements, the BOI should be given the power and the decision-making authority to go on with it now. Though the customs law was within the BOI, though we requested the customs to allow this to go on, to the export to take place, that was not allowed. So the problem is not within the BOI. It is mostly the liner agencies that are working with the BOI. So we have to bring them all around the table. I think the bar association, maybe they can play a lead role in bringing these institutions, because somebody authoritative have to put this foot down and then create a procedure and a process that should be adhered to. Maybe I think, knowing the Sri Lankan situation, it's best that we incorporate it in the BOI law itself with an amendment, suitable amendment, for the BOI to take precedence. And once the decision is made by the BOI, for that to be implemented and then carried out.
Thank you, Mr. Jayasuriya. Just before I leave you, I'll move on. Just one quick question, which is an area which we did not touch, was the question that has been raised, is on the Strategic Development Projects Act. Do you think this act has actually been successful in drawing in investments which are of great economic and social benefit to the country, which has changed the landscape of this country?
Strategic development, the interpretation is different from what it has been now applied. A hotel cannot be a strategic development. An existing industry, if they are to modernize the factory, cannot be a strategic development. This is what it has been used for. I think strategic development now, if we have graphite in this country. Now graphite is exported in gunny bags, but graphite can be developed to a stage where we make nanograpphite and also titanium, right? And for that you require a huge investment to be made. Now these are areas where even either the government or we can attract foreign investors to come in. A nanograpphite, the titanium, a ton of titanium is much more valuable than gold, or the most valuable thing in the world. So these are the strategic developments that has to take place. The development of the tea, its extracts, by way of even to the extent of using it in for various perfumes and so on. Now these are the strategic developments. Unfortunately we have not used this good law, the strategic development, and also there is another weakness I see in the strategic development law. The decision making, identifying a strategic development is given to the cabinet ministers, whereas it should be given to the scientists or at least the board of investment. It should not be given to the cabinet.
Thank you, Mr. Jayasuriya.
It's a political decision.
Yes. Thank you, Mr. Jayasuriya. As we have the constraint time, there are some other questions. Mr. Selvas Kandan, if I may draw on you again, the Electronic Transactions Act has taken out of the scope of the Act any contract for the sale or conveyance of immovable property. Is it time that this was relooked at, given that, especially post-COVID, where there's going to be a restriction on foreign travel, etc.? Is there some way that these transactions could be done in a digital, within a digital framework, while also not diluting the importance or the significance of the Prevention of Frauds Ordinance?
Yes, Rohan, it's feasible, Suren. But you have to see how we connect all those departments and various people involved in a conveyancing transaction. Now, for example, if you take Australia, it is done through a company. Now, for an example, when you enter into the platform and do a transaction, they take the responsibility of registering the documents and all that taken by them. So we don't have such a system here. Even our land title registration system is delayed in this country. If you take our conveyancing deeds are running into pages, it is not just one-page document, a deed of transfer like what you have in England or Australia. So in order to achieve all these things, the security and all that has to be in place. So I think we have to create a system which connects everyone who are involved. That is the seller, the buyer, the lawyers, or the notary public, whoever it is involved in the transaction, and also the transfer of money now. Now, how do we do that? It can be done only by creating one entity which will monitor all these things and get involved in the entire transaction and provide that adequate security so that we avoid all these fraudulent transactions, everything in the process. So it's not that impossible, we can do it, but we have to set up that mechanism in which that we can get it going. But it's very critical, as you said, because we don't know how long people are going to be restrained from traveling from country to country. And we have to look into this very seriously in order to get this transaction going. I know now, if you ask me, there are properties which are completed, high-rise buildings, COC have been obtained, quite a number of buyers are from overseas, and the developers are unable to execute the deed because they are taking their time. And they say, we are sorry, we are unable to come to Sri Lanka because there are travel restrictions. So how do we implement is, We have not thought about all these things. Now take this registration of title, how long it has taken, you know. And recently, I'm very happy to note the president invited them and said it has to be implemented as soon as possible. If that takes place, and then at least we can bring other the people involved in these transactions together and to make it happen.
Thank you, Mr. Vaskandan. There's also a question from one of our viewers. The question is, foreign exchange regulations has a 40% limitation on production of goods, where Sri Lanka's exports are subject to internationally determined quota restrictions. Could you please provide a few examples? Are you in a position to assist on this, Mr. Vaskandan?
Now, for an example, now you take even the garment factories where they operate on a quota, right? Even there, you cannot have more than 40%. Now, Sri Lanka, mainly, if you look at it, in the last so many years, we have been very much involved in the export of garments. That is the main quota where we get from other countries to do business, you know. So that is the only area I can think of where they think that foreign ownership should be restricted, because we have the quota and other people, the foreigners, should not make use of that quota which we have, not exploit and bypass what is restricted to those countries and using Sri Lanka quota for exports.
Thank you, Mr. Vaskandan.
Just one, I will say in the rubber industry as well, the tire exports, and also that is a quota-based this thing, particularly for US, and there are people trying to enter, but that is also difficult because of the quota system.
So I guess you have provided our viewers the policy considerations that unlike some of these restrictions that are placed on certain industries by limiting the shareholding in this. Mr. Vaskandan, just another one more question before I move on, Dr. Gunawansa. In fact, this was something that has been troubling me as well. The question that has been raised are, foreigners are not allowed or restricted to buy landed property outright, but the government lease out public properties to them at a nominal rental for 9-10 years. Doesn't this policy make the way for corruption? Or I mean, is it a contradictory policy that is being followed?
I didn't get your question, Rohan.
The question is, Mr. Vaskandan, that the foreigners are not allowed or they are restricted from buying land, that is freehold property outright, but the government leases out public properties to foreigners for 99 years at nominal rent, or in fact they're allowed to take out lands on lease for 99 years, which is in fact more or less outright transfer. Is this policy, is this consistent? Is it a conflict? Is it contradictory in some way?
But again, Suren, now the government has restricted that to 50 years. Earlier, they were giving 99-year lease. And now they have said they are not going to give 99. They are giving only 50 years lease now, because there were objections raised on that. And after that, the government had decided the leases in respect of any development, for any development will be restricted to 50 years. And they have been implementing that for some time now.
Thank you, Mr. Vaskandan. Dr. Gunawansa, we are coming into the final pellets of time. So there's another question that has been raised by one of our viewers. Are there any investment related cases heard by the courts of Sri Lanka, especially those that have an impact on the investment treaty obligations? Are you in a position to weigh in on this question and provide some clarification, Dr. Gunawansa?
I'm not too sure whether there are any ongoing cases which has any bearing on investment treaties at the moment, Suren. I'm not aware of that.
I believe most of these investment, as I think was explained by Dr. Pereira, are protected on investment treaties which are against the government of Sri Lanka and not individuals. So whatever individual disputes would have to be the resort through the commercial high court, or it should be by way of arbitration.
By way of commercial arbitration, that's right.
Yeah. Just before I leave, we wrap up this webinar. One more question to you, Dr. Gunawansa. There was a recent Supreme Court judgment, the Noble Resources case, where the Supreme Court held that Noble Resources was a company incorporated in Singapore, for the knowledge of our viewers. And the Supreme Court held that the protection under Article 12(1), that the equal protection of the law, is not available to a foreign incorporated company. Is this something significant from an investment perspective, Dr. Gunawansa?
Not necessarily, because I mean the key parts of the judgment, what you said just now, are found in pages 22 and 24 if you read them very carefully. where the Supreme Court first evaluates a previous judgment in Environmental Foundation Limited versus Ranjit Siamalapiti, if I'm not mistaken, where Justice Sarath Silva probably agreed, if I'm not mistaken, with Mr. Faiz Mustafa's argument that although Article 12(1) refers to persons and Article 14 refers to citizens, and there shouldn't be any distinction between those two, and under Article 12 and Article 14 protection should be given to companies registered in Sri Lanka. So in the more recent judgment by Justice Sripavan, which you just referred to, the Supreme Court reconfirmed that position and said that only a company registered in Sri Lanka should have the protection in terms of the Constitution. And they went on to, now that particular case was a unique case where it was in relation to a dispute that arose under the Public Contracts Act, and there was a local agent involved, and on behalf of the Singaporean company who submitted the bid. But the court also went on to say that in situations like that, the local agent may have certain rights as against other local agents, but not the foreign registered company. So that thinking is almost on par with most other constitutions. If you see in other countries also where constitutional protection is given to basic human rights or fundamental rights, that is limited to citizens or persons of that particular country, and not to foreign registrants. So if you are a foreign registrant, then if you come in to do investment in a particular country, if you incorporate yourself into a company locally, then you might be treated, just like any other company, subject to applicable laws. But if you're operating as a foreign entity, then your protection will be under the basic principles of international commercial law, where and also treaty law, where you will get protection from expropriation. Then you will have the right to be treated, under MFN clause, or the equal protection offered, under the investment treaties and so on.
Just one final question. I don't want to disappoint our viewers. The Swiss challenge method that is generally followed in relation to especially developing public-private partnerships and also in relation to infrastructure projects. Do you think this is a very successful method, Dr. Gunawansa?
Absolutely not. The reason for that is when it comes to unsolicited bids, the bid itself involves a lot of intellectual property. Now, the Swiss challenge mechanism requires you to make available a particular proposal put forward by an investor in order to invite parallel bids from other people. And then you give like a first right of refusal to the original bidder. Now, if somebody has intellectual property involved in developing that proposal, and you don't want to divulge your technology, to your competitors, then the Swiss challenge mechanism would not work. Now, Swiss challenge mechanism would ideally work in a different situation. Say, for example, the Sri Lankan army wants to buy, 100,000 tires for its vehicles. So there the competition is between brand A, brand B, brand C, and brand D. So in that situation, somebody submits an unsolicited proposal, then that I can give you a tire at $100, right? And then you channeling it through a Swiss challenge mechanism is not going to violate any kind of intellectual property. And also the party who is submitting the bid will have no reservation going through that. So if we have the Swiss challenge mechanism practice as it is available at the moment, that would basically discourage a lot of innovative proposals from being submitted to the government of Sri Lanka.
Yes, I think that is also a topic by itself, I think, which requires far deeper and greater detailed discussion.
Absolutely.
And diving into. Gentlemen, I think we have exhausted our time. It's a Saturday evening. I don't think we want to take 1 minute more than what is required for all of us and all our viewers' weekends as well. So thank you very much, gentlemen. It has been a very interesting and a very informative discussion. It has been a pleasure moderating this. And have a good weekend. Tanya, over to you.
Thank you, sir. Thank you so much. Cost fees of investment law that we have been discussing today. A very special thank you to all our panelists who have participated. given us their time, their energy, their advice, and their generosity in understanding and appreciating and learning a little bit about arbitration that was touched on in this webinar. There is yet another webinar by the Bar Association happening on Tuesday on the topic of international investment arbitration. It takes place on the, be required to register before the 13th. Thank you to our moderator. Thank you to our panel of experts. Thank you to our participants. And thank you to Rajiv Amarsurya, whose idea it was to bring this webinar together, 9th episode of which is what you have been witnessing today. Thank you also to our president of the Bar Association, all the behind the scene activity that goes on in all to you and all the staff of the Bar Association. Thank you and good night.